Welcome everyone. It's the second part of our webinar set on Russian data privacy rules. And in this part, unlike in the first part, we'll cover Russian specifics. So in the first part of this series, we covered the general regime under Russian law and its history, so how it was derived from the previous EU regime, the key notions of the Russian data privacy regime, such as personal data, data controller, data processor, and various others. We've also covered liability in the first part of the seminar, of the webinars. And now we are going to cover more specific rules of Russian data privacy law. So the first concept that we wanted to look at are grounds for data processing. So under Russian data privacy law, any data controller, so a person processing data, must have a ground for such processing. There are essentially two sets of grounds. The first one and the first and foremost ground is the consent of the individual for data processing. The consent may take different forms. So it can be a simple form consent, for example, such as ticking the box on the website, or it can be something like agreeing to use the service. It can also denote the agreement to processing of data, especially where the use of service, for example, a website, is accompanied by a privacy policy on a certain web page of this website, which says that the mere use of the service is the consent of the individual to relevant data processing as described in such privacy policy. Vadim will talk more about privacy policies. And the second type of consent is a qualified consent. So qualified consent usually takes the form of a wet ink consent, satisfying a number of requirements. These requirements include, for example, the purposes of processing, the types of data processed, the period of processing, the ways of how the data are processed, the procedure for the revocation of the consent. And this qualified consent is only necessary in certain specific cases, for example, with respect to processing of health data or with respect to data which are being cross-border transferred to certain countries, which according to Russian law do not provide adequate protection of personal data. A simple consent, which we covered before, is something that is generally sufficient for data processing unless the qualified consent rule applies. So that's the first and foremost ground for processing, consent. The second set of grounds for data processing includes anything which is not consent, and there are a number of such grounds. These grounds include processing in the context of law enforcement proceedings, in the context of court proceedings, processing for carrying out the contractual arrangements, for example, where the processing is required in order to execute an agreement, for example, to deliver the goods or services. Then processing is allowed without consent with respect to publicly available data, being the data which was published by the individual, him or herself. For example, any data published on social networks. Another exception is processing of data by mass media and journalists, and this is an exception which is usually used for processing of data of politicians and other public figures. There are also additional exceptions, for example, scientific purposes or medical purposes, but these are usually accompanied by a requirement to have the relevant personal data anonymized. The notion of anonymization under Russian law is quite different from the notion set out in the GDPR. And anonymization is basically when the personal data are deprived of their nature of being personal data, i.e. they no longer identify the relevant individual, and the anonymization may take the form of setting numbers instead of names and other data which does not by itself allow to identify the relevant individual. So all these grounds, both the consent and the second set of grounds, which are basically an exception from where consent is necessary. And they are both very similar to those set out under the GDPR. So whenever the processing is allowed under the GDPR, it's most likely allowed under the Russian data protection law. However, it's key to verify this, and it's key to take into account that the Russian data privacy law is not well tested. And given that it's not well tested, virtually none of the exceptions to the consent requirements have been properly tested. And we always advise clients to try to obtain consent where possible, qualified consent, i.e. in the wet ink form, and where it's not possible, just a simple form consent. So I guess that's what we wanted to cover on the consent requirement and on the anonymization requirement. Now Vadim will talk about privacy policies and certain notifications which can be filed to the Data Protection Authority.
Thank you, Ksenia. As a matter of Russian law, data controller or data operator, how it is called in the Russian personal data law, is obliged to adopt multiple privacy policies that include user privacy policy that applies to all users and shall set out rules on internal operations with user personal data, confidentiality policy that applies to all users and that shall set out rules of personal data confidentiality, and privacy policy relating to employee personal data that should cover internal operations with employee data if the relevant NGO has Russian employees through established branch or a separate legal entity in Russia. Each employee should acknowledge the relevant employee privacy policy in wet ink. User privacy policy and confidentiality policy are, if needed, can be merged into a single document. And this is usually done by the Russian data operators. Also, these privacy policies shall be made publicly available and must be in Russian. If the data controller or data operator, how it is called in Russia, is processing any personal data subject to limited number of exceptions, it should notify Roskomnadzor, the Russian Data Protection Authority, on personal data processing before commencement of such processing itself. Notification processing requires completion of notice form on the Roskomnadzor website and sending the executed paper copy to local Roskomnadzor office in the particular Russian region where the data controller is located. For example, in Leningrad region, in Moscow region, in St. Petersburg, in Khabarovsk, etc. This notice shall be sent prior to processing of any data. Roskomnadzor, however, from time to time, issues requests to data controllers to send these notifications and does not find for failure to submit a notification before such request. This practice is mostly driven by a large number of participants that do not comply with the rule on notification of data processing. And from time to time, the Russian Data Protection Authority has been loyal to such data controllers as it doesn't find any material violations of the PD law. Also, we would like to make a focus on the exceptions that might be applicable to NGOs in respect of the notification of data processing. So under the Russian personal data law, these include processing of employee personal data, carrying out the contract with the data subject, if relevant, personal data of religious organizations or NGOs, if personal data is not transferred to any third party without consent, processing of personal data without the use of any automated means, processing of the name only, processing for the purposes of granting access to a certain territory, for example, providing an electronic pass to office, and processing of publicly available data. So on this slide, we outline the questions to check the key takeaways from the previous material that we have discussed. So please assess these questions yourself, and we will give you the answers shortly.
So next requirement that we wanted to cover is a set of rules which relates to data localization. So data localization is a Russia-specific requirement, and we would like to highlight this rule especially as fines for non-compliance therewith are quite high. Actually, these are the highest fines for non-compliance with the rules, and non-compliance may potentially lead to blocking of the relevant service, for example, the website or of any other resource such as an application in the App Store, including where this relates to any NGO's application or website. So the fines for non-compliance with this rule can be up to $300,000, and that's the highest fine provided for under Russian law. So the data localization rules require that data controllers collect personal data of Russian citizens on servers located in Russia. This rule sounds quite short, but at the same time it's quite tricky, because in the first word, which is collection, this first word has not been interpreted by the Russian authorities earlier, but after the rule was adopted, effectively the Russian authorities said that collection is only where personal data are collected or received directly from the relevant individual, for example, by way of filling in the form on the website. So that's collection of personal data. And at such collection, any data controller shall collect the data into the Russia-located database first, and only then this data can be subject to cross-border transfer. This rule, the localization rule, does not prohibit cross-border transfer, but it means that the data shall first go into the Russian database and only then can be transferred to foreign databases. So that's how the rule is supposed to be working. And the localization rules cannot be disapplied by obtaining consent of the data subject, so it's key to comply with these rules. There are practical identification problems. For example, it's difficult to identify whether a person is a Russian citizen, so what we advise is, if you have any fear or any intention to collect data of persons from Russia, you can have a form whereby one of the questions is the citizenship, and if the Russian person ticks the box that he or she is a Russian citizen, the data should flow into the Russian database. Not all NGOs, of course, have Russian databases, but Russian databases can be leased. It can be quite expensive, but it can also be, in some respects, cheap, in some cases cheap, especially when you team up with other NGOs and you have a database in the territory of Russia. So as we said, the compliance with the rules is mainly to quite tricky liability. It can be fines, and it can be blocking of the relevant resource. and there have been an increasing number of enforcement cases, and especially against global entities. So we advise you to very carefully look at the relevant requirements and comply with the Russian data localization rules. Further on, we'll talk about cross-border transfer of data. So Russia, similar to the GDPR, has rules prohibiting cross-border transfer, especially cross-border transfer to certain countries. The rules are so therefore country specific, and there are two categories of countries. So the first category is so-called whitelisted countries, and these include countries which are signatories to the Strasbourg Convention. Basically, it's all of the European countries and certain other countries, plus countries which are not signatories to the Strasbourg Convention, so non-European countries, but which have been specifically whitelisted by the Russian Data Protection Authority. And these countries, the list of such countries change from time to time, but it includes, for example, South Korea. Most notably, another set of countries which are not whitelisted are so-called blacklisted countries, or countries which are not signatories to the Strasbourg Convention and not specified in the whitelist of the Russian Data Protection Authority. Most notably, these countries include the US, and so any transfer to the US is not specifically authorized under Russian law. The only way to ensure the transfer to such countries which are not whitelisted by the Roskomnadzor is allowed is basically to obtain a consent of the individual. Under Russian, strictly speaking, under Russian law, such consent must be wet ink, but as it's difficult in the global and IT worlds, certain IT companies rely on not wet ink forms, but a simple privacy policy or a simple consent. Ideally, the relevant wording of the consent should, if not in form, but in contents satisfy the requirements to qualified consent, i.e. it should specify the personal data processed, the purposes of processing, and further information about processing. So there are further data-specific restrictions in addition to cross-border transfer, which may apply to certain types of data. For example, state secrecy may not at all be transferred outside of Russia, and state secrecy in certain cases may include personal data of officials or other persons. And generally, the cross-border transfer regime in Russia is based on the one set out in the European rules. The European rules set out a number of derogations whereby transfer to countries not providing adequate protection to personal data can be allowed. One of those is consent, same as in Russia. And the GDPR, but the GDPR sets out a more broad list of derogations which allow transfer to third countries not allowing adequate protection, whereas in Russia it's normally either consent or carrying out of an obligation with an individual, but the second one has not been properly tested in courts, and therefore we also advise to take a note that whenever you have a cross-border transfer from Russia to the US or to another jurisdiction which is not European, you should first verify whether it's whitelisted, and second, try to obtain specific consent, which should mention specifically the relevant country of transfer. So that's it about the cross-border transfer rules.
Here we would like to give an overview of the Russian requirements to engaging data processors, the persons that are processing the personal data on behalf of data controllers. So, as it was discussed in the first part of our webinar, Russian PD law doesn't directly provide for a notion of a data processor. However, there is a separate regulation that applies to data processors and their activity. In order to comply with the Russian personal data law, and in order to engage the data processor, you should follow the two-step process. The data controller shall obtain consent from the data subject that ideally shall specify the name or at least the category of data, and enter into relevant agreements that might be services agreement, sale and purchase agreement, or any other commercial agreement that will contain specific provisions. These specific provisions in the agreement are necessary for the purposes of compliance with the Russian personal data law. The relevant agreement shall set out the rules and procedures applicable to processing of personal data, provide for an obligation of the data processor to adopt measures that are technical and legal to ensure data security, and oblige the data processor to ensure confidentiality of the received data. Here we have outlined some of the questions of the previous part of our presentation, so you can check yourself. Please consider these, and we will give you the answers shortly.
So now I wanted to talk about specific rules on data breaches. There are a number of countries which oblige data controllers to notify the relevant authority, the data protection authority, or any other authority of any data breach. And this topic is especially acute in the modern world. And basically, in Russia, there is no formal obligation to notify the data protection authority or individuals of the data breach. That's unlike under the GDPR. However, there is a draft law to introduce this obligation because Russia is a party to a protocol to the Strasbourg Convention, which provides for the need to have in an internal law an obligation to notify any data breaches to the authorities and individuals. And therefore, we expect that Russian law would soon provide for an obligation to notify of data breaches. Russian law has also a separate set of notifications, which provide for notifications of data breaches to certain authorities, especially to law enforcement authorities and security authorities, for example, the Federal Security Service. However, the notifications there are only to be filed by certain types of entities. And this relates especially to banks, insurance companies, and the like. And it doesn't usually refer to NGOs and shouldn't usually encompass NGOs. However, if you are an NGO, you should try to verify whether you are subject to a law on critical infrastructure in Russia, under Russian law, which is basically the law which provides for this type of notifications. So that's it on this notification rules. And now we'll go to talk about a practical case study, and Vadim will cover this case study.
Thank you very much, Ksenia. So in order to recap all of the Russian specific rules, we decided to include this case study into our presentation. So please take a look. Look through the question and try to answer this question by outlining relevant rules that should apply to the described situation. We will give you some time to think about the case, and after we will provide you with our answers and we'll describe how the rules should be applied. So, from the description, we understand that non-profit organization will be processing personal data of Russian students and probably its Russian employees, if any, in Russia. We understand that the relevant personal data will be transferred to United States, will most likely be transferred to United States. So NGO will be processing the relevant data and will be deemed as data controller or data operator, how's it named in the Russian personal data law. As a result, the NGO will have to obtain consent from the Russian students, employees. Please note that the consent for processing of personal data shall provide for additional consent on cross-border transfer of data and transfer of data to the third parties if applicable. Also, the NGO will be, as NGO will be deemed as a data controller for the purposes of compliance with the PD law. It will be obliged to adopt the user privacy policy, separate privacy policy, employee privacy policy, right? That will apply directly to the employees if there are any in Russia. And both of these privacy policies will have to be adopted in Russian language. It will also be obliged to notify Roskomnadzor on data processing and follow the localization rules, so store and process data on servers located in Russia. As it was recently discussed, there are also rules on cross-border transfer that will be applicable in that situation if the data is transferred to United States. As was mentioned by Ksenia, the first step that NGO should take is assessment whether the United States is a restricted country. So currently, United States is a restricted country and is on the Roskomnadzor restricted list. Therefore, the NGO will be restricted from transferring the personal data of Russian students to the United States. Please note that for the purposes of assessment, there are also additional rules on type of data that can be transferred. The transferred data shall not include data information constituting privacy of communications or state secrecy data.
So on this slide, we have outlined some additional rules which may apply. These are strictly speaking not personal data protection rules, but they are closely related to personal data protection regime and privacy regime, and therefore wanted to briefly cover those. So the first set of rules are Yarovaya law, and these are rules requiring certain entities, especially telecom operators and so-called arrangers of information distribution, for example, messengers and some of the types of the websites, to retain certain types of data within a Russian database. So again, a Russian database as in the Russian data localization rules. Not only data retention is required, but also provision of access to data by the relevant IT company to the Russian law enforcement authorities may be required. This set of rules was originally the subject of debate, but it was initiated as part of attempts to combat terrorism. Therefore, basically, these rules imply that metadata, being for example, the data about when the message was sent, and contents of messages and communications are to be stored within a Russian database. These rules are quite difficult to follow and unlikely to apply to NGOs. However, if you have or run a messenger or a similar type of service, you may be required to comply with these rules, and you should verify such compliance. The second set of rules is about user identification. This is again more acute for messengers. Messengers, if you run messengers as a separate applications or messengers within your websites or web pages, you should verify that you actually identify the users which can use the relevant messenger. The user identification rules primarily relate to the fact that the users must register via their mobile phones. So the notion of information arrangers and the rules thereon are, as briefly described above, relates to messengers and other types of services which distribute metadata and contents of communication via internet. It's a very broad definition which may encompass various types of entities and is subject to various types of rules, but primarily Yarovaya rules. There are also rules on RUNET, which oblige, again, internet providers, telecom operators, holders of autonomous system numbers, for example, large companies with autonomous system numbers which run their own IT, and owners of certain other IT resources, to ensure that data centralization of traffic is achieved in Russia. Basically, the RUNET rules are new and to some extent untested, but they are very broad and they can cover virtually anyone, including some NGOs. For example, these NGOs may most notably be required to attend certain trainings by the Russian Data Protection Authority to make sure they understand how the rules apply and what they need to do under these rules if the authorities notify them that there is an emergency and that data traffic has to be centralized. Then there are also various other rules which apply to owners of audiovisual services, VPN services, and these rules are very new, complex, and to some extent unlikely to apply to NGOs. That's why we don't cover those here in detail. However, if you are interested in any of these rules, or you have heard any rules which are enacted in Russia but which you don't understand, please feel free to reach us, and we are happy to explain the rules to you in more detail.
So here we would like to illustrate the recent developments in Russian data privacy that emerged as a result of COVID-19 outbreak. A Russian Data Protection Authority, Roskomnadzor, have issued the interpretive guidance regarding temperature measurement in the offices. As a general rule, the Russian personal data law provides for restriction on processing of data concerning health. Processing of medical data can be made only with the written consent of the data subject. Such consent should be wet ink. So in its interpretive guidance, Roskomnadzor has allowed the temperature measurements without obtaining the wet ink consent, as in case of temperature measurement, consent is given by personal data subject by his or her implicative actions. However, this approach adopted by Roskomnadzor is questionable, as it most presumably contradicts the Russian personal data law and cannot discharge the data controllers, or data operators, how they're called in Russia, from obligation to obtain written wet ink consent as set out in the Russian personal data law. So another recent development in Russia that relates to COVID-19 outbreak was the adoption of electronic passes, the QR code type, that was required to move on the territory of Moscow, effective from 15 April 2020. All individuals older than 14 years old were obliged to apply for e-passes prior to making any movements by car. So movements on foot are restricted to going to nearest shop and similar, or seeking for medical help, medical assistance, and so on. E-pass is issued for 1 day and limited on 2 electronic passes a week, other than for medical purposes, on when the person is traveling to work or is a volunteer, to which the limitation does not apply. So currently, all of these are discharged by the mayor of Moscow, and there are no restrictions relating to COVID-19 that apply in Moscow. So now I would like to give a word to my colleague Ksenia to finalize this second part of our Russian data privacy presentation.
Yeah, thank you, Vadim. So basically, in this second part of our webinar on the Russian data privacy regime, we have covered Russia-specific matters and have also compared some of the rules with GDPR. So if it's helpful, I could summarize what we discussed during the second part of the webinar. And first of all, we talked about certain Russian-specific requirements to data processing, grounds for data processing, including consent. We've also covered cross-border transfer of data and specific consent requirements applicable to such transfer. We have covered the certain obligations of the data processors, such as having in place privacy policies, having in place agreements with data controllers, having assuring databases in Russia for collection of data about Russian citizens. We've also covered the data breach requirements, so far basically non-existent other than with respect to certain specific types of entities. We have done a case study and we have very briefly covered certain specific rules and talked about certain COVID-19 related measures. So we hope you found this part of the webinar and the previous webinar interesting and helpful, and we would be happy to address any follow-up questions. And thank you, Pilnat, very much for this opportunity to host this webinar.